stands ready to be in opposition to the one presenting evidence. Proponent and opponent. And think about this very important detail in the rules. That is, the federal rules of evidence put the burden on the opponent always to stand and object, to stand and voice what's wrong with this evidence. So if someone's silent, if someone says stay seated, if someone's asleep at the wheel, the proponent, the one putting on evidence, can literally do almost anything they want in a court of law. Only in rare occasions does a court step in, does a judge step in and handle things sua sponte. We put the burden on the opponent, the other side, the opposing counsel, to voice an objection. And in most courts, it's standing on your feet, saying the word objection followed by a basis under the rules. But think about those different rules, the different articles. Article 4 for relevance, Article 8 for hearsay, Article 6 having to do with witnesses, and character evidence again under Article 4. All of them pose different hurdles that all evidence has to overcome. And if you think about evidence, could be a document, could be a photograph, could be real evidence, could be a question posed by an attorney, could be a prospective answer from a witness. Anything that has the prospect of being admitted into evidence, if it's an actual exhibit, or the prospect of being heard by a jury in open court, is subject to the rules. At trial, subject to the rules of evidence. And it is for the opponent, it is for the opposition, it is for the one getting in the way of the proponent who's putting on evidence to put up these hurdles, to lodge these objections, to say any evidence that's going to come in at trial, be heard by a jury at trial, or prospectively be admitted in as evidence and be available for the jury during their deliberations, has to overcome all hurdles, has to come all hurdles that are raised by the opponent. So think about that. Now, there's a lot of different ways to organize an evidence course. This is something I offer my students to try to help give them an idea of the big picture. And while, questions 4 through 10 really go through the different rules. Again, starting out with relevance, the first hurdle, all evidence has to be relevant. If you read 401 and 402, all evidence has to be relevant. And then it goes on through the different rules, through hearsay, through character, through opinion evidence, whether it be expert or lay opinions, through privilege. And I strategically put 403 last because it is that last-ditch effort. Even if evidence overcomes all other hurdles, there might be something to say of the dangers of 403. But what's less important here are the actual organization and trip through the rules and how I've organized questions 4 through 10. What's more important are some of these questions we have to think about before we even get to the first rule. And if you look at my 1 through 3, this is what we're talking about. So first, 1, where are we? What I mean by that is in the question or in the scenario or whatever you're considering at the time of the evidence, where are we? Are we at trial where the rules of evidence apply, or are we at some other hearing? Are we in grand jury? Are we at a motion hearing? Are we in sentencing? Are we at a conference room back in a law firm? Are we on the street with a police officer? Where are we is the quickest way to dictate whether the rules apply or not. And of course, there's rules 1101 and other rules that can help us with that. But asking the question and taking that first question, where are we? At my school, I teach in California, so I oftentimes teach distinctions having to do with the California Evidence Code, the CEC, versus the federal rules of evidence. Where are we can dictate what rules of evidence apply. If you're in California state court, the California Evidence Code is going to apply. If you're in federal court, of course, the federal rules of evidence are going to apply. If you're in military court, the military rules of evidence, which mirror the federal rules, are going to apply. So where are we is a very helpful question to make sure that you're off and running in the right direction. Do the rules apply? And if so, which rules? Next, and I got to tell you, this happens with almost all of the rules. What is the proponent trying to do? What is the proponent trying to prove? This dictates how we come out on evidence all the time. Think about it. The proponent is engaged in their trial presentation. They're asking questions of a witness. They are trying to put on exhibits and trying to admit exhibits at trial. They're trying to go through their trial presentation. And what dictates whether that evidence may come in or whether it may be excluded at trial, where an objection is sustained and they agree with the opposing party, agree with the objection, or whether it's overruled and they disagree with that objection, really turns on so much what is the proponent trying to do? What is the proponent trying to prove? And so much of this second question comes down to argument. If I'm the opposing party, if I am the opponent, I'm trying to say that the proponent's trying to prove something or trying to do something they're not allowed to do. Hey, they're going into improper character. They're trying to introduce this for an improper purpose. They're trying to get into this out-of-court statement for the truth of the matter asserted, which is not allowed under the rules. I'm going to argue from the perspective of the opponent that they're doing something they're not allowed to do. Conversely, if I'm the proponent at trial, I'm going to argue that I'm able to do what I'm trying to prove. Here's what I'm trying to prove, and here's why I'm entitled to do that under the rules. And lastly, you see what is the evidence. So many answers come out, and so many evidentiary discussions happen over at sidebar or even in motions in limine, where you can get lost as to what evidence are we talking about. In the subject of evidence, we have to be very clear in our motions in limine, in our evidentiary discussions at sidebar, and even in our objections in open court. We need to be very clear what evidence we're talking about. Is it the question that the attorney is asking? Is it the prospective answer that the witness may give? Is it a document or photograph? Is it a real exhibit like a baseball bat or a knife? What is the evidence at issue? Because when we know what the evidence is at issue, we know what objections we can make and what a sustained objection or an overruled objection means with respect to that evidence. Don't lose sight of these three questions at the beginning of any organization of evidence. The where are we to tell you what rules to apply, or if the rules apply at all. What is the proponent trying to do? It's at the front end of so many of the rules that we'll talk about in these videos and in any evidence course. And finally, never losing sight of what is the evidence at issue. Again, the burden is on the opponent to raise an objection and to raise all objections, to pose all hurdles to the evidence. So you got to never lose sight of what is that evidence we're talking about. You can see through the objections and responses, I talk about this in a number of different ways, but it always starts with the opponent. Again, if that opponent sits down, if that opponent is asleep at the wheel, if that opponent is having a bad day and doesn't get in the way of much, then there's going to be a lot of evidence from the proponent, from the party presenting. There's going to be a lot of evidence that comes in, proper, improper, for the jury's ears, or not. It's going to come in unless the opponent stands up, objects, and offers a basis for that objection under the rules. From that point, it's really for the proponent to decide. They were the one putting on the evidence. They know what they were trying to prove or what they were trying to do. It's for them to decide whether to invoke sidebar, whether to ask judge for a sidebar. And the proponent's the one that knows, is this the type of information, is this discussion that we're about to have on this objection, is it appropriate for the jury's ears? Can they hear the argument in support of what I'm about to do? If they can, then you can stay in open court. If they can't, which is more often the case, it's for the proponent to say, request for sidebar, go over to sidebar, and then get into the response. So whether at sidebar or in open court, Your Honor, and here's my response to whatever objection was, and I want to use the rule. So many of our rules that we're going to talk about and the arguments that derive from these rules are pulled right from the operative language of those rules. Your Honor, I'm going to argue in response to this objection, and I'm going to use the rule language from my perspective as the proponent as to why I'm entitled to do what I was doing. And then the dance goes back and forth. Your Honor, I'm going to now, for the first time as opponent, argue in support of my objection. I offered you objection and the basis for the objection. That's it. It might be 2 or 3 words. Objection irrelevant, objection hearsay, objection improper character. Now I get to offer my argument, and I get to offer it contrary to whatever the proponent came up with. And back and forth it goes. Maybe you have the type of judge that says counsel and ask for more argument. But at some point, the evidentiary discussion rounds out. The arguments reach their peak, and the judge has to rule. You get the judge's ruling. And the most important thing we can do after the judge's ruling is understand that ruling if you're the proponent, and seamlessly go back to your presentation. Seamlessly return to the trial skill of presenting. And as the opponent, you want to also understand the ruling, but you want to then poise yourself and listen for the next objection or to defend the objection that was just sustained. Of the perspectives of this case, don't lose sight of those preliminary questions about where are we and what is the evidence and what is the proponent trying to prove, and understand that dance that goes back and forth. Objection basis from the opponent, Your Honor, here's my response, whether over at sidebar or in open court, from the proponent. Here's what I'm trying to do. Here's what I'm trying to prove. Back and forth until the judge rules, and then everyone returns seamlessly to their sides of the case. The proponent continues to present, continues to put on evidence. The opponent continues to be poised and ready to lodge the next objection.